So today we look at bail pending trial. Today we're going to look at bail pending trial. So why in the course of trial, in the course of trying a person uh, for any offense, it is still possible that such a person can be entitled to bail. You understand? Depending on the nature of the offense in question. So bail pending trial is simply a temporary release from custody. Pending the trial of the person. Ordinarily, if a person is being tried, trial is usually long in Nigeria. It doesn't happen in one day. Today they will bring the person from from maybe the correctional center, and then after the trial, they will take the person again in the van to the correctional center. They will adjourn, adjournment upon adjournment upon adjournment. You might be asking yourself, during those period of adjournment, where is the defendant? The defendant is usually in prison, or as we call it now, correctional center. You understand? So it's possible that in the course of trial of a person, the person can apply for bail. You understand? The person can apply for bail pending trial, so he can be on bail. Why? And then he can be on bail. Pending his trial is possible. You understand? See Suleiman against COP. So the courts generally have power. You understand? The courts generally have power to grant bail. You understand? And bail is the right to bail is a constitutional right. You understand? Is a right that is tied to the right to personal liberty. You understand? So even if you're trying a person for an offense, it doesn't mean that he should be detained in maybe whatever correctional center or prison because he's being tried. In the course of trying him, you can still allow him to go, you know, to go and do his business or whatever he does in the society. Pending the trial, or let me say pending conclusion of the trial. You understand? So the right to bail is hinged on the right of a person's personal liberty. A person's right to personal liberty and the right to freedom of movement. You get. So generally, a person is entitled to the right to personal liberty. However, it is possible that this right to personal liberty can be curtailed. You understand? So it can be curtailed pursuant to a court order that a person be brought to court. You understand? So generally, like I said before, a person is entitled to the right to personal liberty, but this right can be curtailed where, in consequence of a court order, he's made to brought to court, or where there's a reasonable suspicion that he has committed an offense. In that case, he'll be arrested and detained, or where maybe for the purpose of preventing him from committing an offense, he can still be arrested. You understand? And in this case, any person arrested above must be brought to court within a reasonable time. For instance, within 24 hours, where the police station is about 40 kilometers radius of the court, or 48 hours in other instances. So now we're talking about generally a person's right to personal liberty. I told you that bail is hinged on a person's right to is hinged on a person's fundamental right to personal liberty. So now, since a person has a fundamental right to personal liberty, now it is possible that this right to personal liberty can still be curtailed sometimes. So it could be curtailed in any of those three instances. But now the law went on further to state that once it is curtailed, that means the person has been arrested and detained. That such a person should be brought to court within a reasonable time. For instance, within 24 hours. If the police station where he's held is like 40 kilometers away from the court premises, he should be brought to court. Or in any other situation, he should be brought to court within 48 hours. You understand? So in other instances, you should be brought to court within 48 hours. That is, if the police station is not 40 kilometers away from the court premises, then you should be brought to court within 48 hours. But then it's relevant to note that this principle of being brought to court within a reasonable time, 24 hours, 48 hours, it does not ordinarily apply. Like, it doesn't apply. It doesn't apply for capital offenses. You understand? So if a person is charged with, if a person is arrested for a capital offense, such as treason, armed robbery, murder, you understand? If such a person is arrested and detained at a police station, for instance, for an offense of murder, now you cannot say within 24 hours he should be brought to court, or within 48 hours he should be brought to court. He should not be detained beyond the 48 hours. You understand? It doesn't apply for capital offenses. You understand? But even if it does not apply for capital offenses, the law remains that you cannot hold a person at a police station in perpetuity. You cannot hold a person in police station forever. You understand? So even if he committed a capital offense. If you look at section 35, subsection 4 and 5 of the Constitution, you understand, you will notice that they said if such a person ordinarily is not entitled to bail, you understand, if for instance a person is held in custody and then from the nature of his offense is not entitled to bail, and then when we hear the word that someone is not entitled to bail, what should come to our mind is when a person commits a capital offense, although it's not absolute. You understand? Although it's not absolute, but for the purpose of this provision of the law, we can say, oh, people who committed capital offenses punishable by death are ordinarily not entitled to bail. You understand? So in that case, even if the 24 hours or 48 hours reasonable time bringing them to court will not apply, but they cannot be held forever. Now, what the law is saying that those set of people who committed capital offenses, they should not be held with beyond 2 months. You understand? The police should not hold them beyond 2 months at the police station. Otherwise, they should be released conditionally or unconditionally. You understand? So they should not be held beyond 2 months. They should be charged. They should be brought to court within 2 months. What kind of investigation is the police doing that they cannot conclude within 2 months? They should be brought to court within 2 months. You understand? They should be brought to court within 2 months. And then it's relevant to know that power of the police officer, power of the court to grant bail, pending trial is discretionary. You understand? It's discretionary. It is at the choice. It is within the choice of the court to decide if they want to grant bail or not to a person that is being tried. And then we might ask ourselves, which court is to grant an application for bail? Which court is to grant an application for bail? Now, the court that will grant an application for bail made by a person standing trial will depend on the nature of the offense. You understand? Will depend on the nature of the offense. If an offense is a capital offense, the law is that only superior courts can grant bail. I was telling you something just earlier, that when it has to do with capital offense, ordinarily they are not entitled to bail. But I made you know that it's not absolute. You understand? There are still some exceptional instances where the court might want to grant them bail. You understand? For instance, one of the major instances in the case of e-health. Understand? The person is extremely sick. If a person is in custody and the person is extremely sick, and then the Nigerian Correctional Service, the hospital there or the medical facilities there are not competent enough to handle him. Such a person should be granted bail so he can, even if he committed murder, he should be granted bail so he can go and treat himself and then still come back for trial. You understand? So in that case now, for capital offenses, it is only the superior courts of record in Nigeria that can grant bail. For instance, the high courts that can grant bail in the course of a trial for capital offenses. But then it's relevant to note that, for instance, under the ACJ in Kano, deemed or presumed to be applicable in the North generally as well for the purpose of your bar finals, Sharia courts, upper Sharia courts, not just Sharia, not Sharia courts, upper Sharia courts in ACJ Kano can grant bail for capital offenses. And then magistrate courts can also grant bail when they are handling what they call remand orders or remand proceedings. When we go further, we'll know what remand proceedings are. You understand? So magistrate courts can also grant bail for capital offenses when they are handling remand proceedings. And then for non-capital offenses, that is offenses that are not punishable by death. Now, the magistrate courts, either the magistrate courts or any superior court, understand? So both the magistrate court can grant bail for non-capital offense. Superior courts like high courts can also grant bail for non-capital offense. Now, it should be asked, can an application for bail be made orally? You understand? Application for bail can be made whether orally or in writing. You understand? Now, in this case now, please, I want you to know that when we talk about bail here, we're talking about bail pending trial. That is bail that is sought in the course of trial. You understand? They are trying a defendant and then he's applying to the courts for bail. This is no longer police bail. You understand? We're no longer talking about police bail. So please bear that in mind. So can an application for bail be made orally? Now, in court, an application for bail under the law, under our legislations, it can be made whether orally or in writing. But there's something called rules of courts. You understand? Some courts can say under their rules that application for bail be made in writing. For instance, superior courts in Nigeria, high courts, federal high courts, under their rules, you understand? under their rules, under their rules or based on their practice directions, they will usually require bail to be made in writing. You understand? So even in such an instance, if an application for bail is made orally in such an instance, it will be improper for the court to strike it out or for the court to refuse. You understand? The proper thing the superior court is to do is to request the counsel to make the application in writing. You understand? And not orally. So the court should not refuse to grant the bail. Instead, the court should direct the counsel that he should make the application in writing in line with the rules of the court. You might see the case of Abiola against Separoyan. You understand? So, who has the burden of proof in an application for bail? Now, if a defendant is making an application for bail while he's being tried, the burden of proof is on the prosecution. You understand? To show that the applicant is not entitled to bail. You understand? So he can adduce credible evidence to the effect that probably if the defendant is granted bail, that he might abscond, or he might not make himself available again for trial. You get? So the burden of proof is on the prosecution to prove that the applicant is not entitled to bail. Now we ask, can bail be granted for capital offense? You understand? Can bail be granted for capital offenses? Generally or ordinarily, a defendant who is being tried in the court for a capital offense cannot be granted bail by the court. You understand? The court cannot grant him bail pending trial, ordinarily or generally. You understand? As a rule, they are not entitled to bail unless in the case of exceptional circumstances or except for special circumstances. You understand? Where the circumstances is a special one or is exceptional, the court can go ahead and grant him bail even if the defendant committed a capital offense such as murder. So now special circumstance, like I told you before, relates to health, sickness. So if the defendant is extremely sick and the facilities available at the correctional center or prison cannot adequately take good care of him, so in that case the court can grant him bail so he can go and treat himself in a very much competent medical facilities. You understand? So application for bail is usually made by way of motion or by way of summons. You understand? I know we have never heard that since I've been explaining criminal litigation. Now, application for bail, you'll find this variation only in bail. Application for bail can be made by way of motion or by way of summons. Summons for bail, motion for bail is all the same thing. It's just variation. You understand? ACJL Lagos uses summons. South uses summons, but the North uses motion. You understand? They use motion for bail. Now this is just for bail. You understand? So don't take it generally that this is how it applies in every other thing. No, just for bail. When it has to do with application for bail, understand? The South uses summons. That is the ACJL Lagos South uses summons. Why ACJL Kano North uses motion. You understand? Uses motion. Uses motion. So in your motion for bail or your summons for bail, you must support every motion with two things: an affidavit and then accompany it with a written address. Like I told you from the beginning, an affidavit will usually contain statement of facts. You understand? We usually contain statement of facts. You're trying to show the court, you're making avowment. It's a statement of fact, trying to tell the court why you should be granted bail. You understand? In your affidavit now, you will tell the court you are sick. You will tell the court, anything you do in court, you don't go to court and be telling the court orally. Most things now are in writing. You understand? Most things now are in writing. The only time counsels are allowed to address the court are oftentimes during their opening address and during their final address. Now, everything you do in court is in writing. In civil litigation, for instance, before the trial, you have already front-loaded. You have already filed your processes, your statement of claim, list of witnesses, list of documents to be relied upon, and all those things. You understand? So in criminal litigation as well, before trial, you have filed your charge sheet, you have filed your information, proof of evidence, list of exhibits, list of witnesses. You understand? So most things now are done in writing. You understand? So in you're applying for bail by way of motion or by way of summons, you support it with an affidavit. You'll see the sample of the affidavits at the ending part of this lecture. So the affidavit usually contains statement of fact. You're sick. The hospital cannot take care of you. You have this sickness. So that is what you will usually find. Just a statement of fact showing why the court should grant you the bail, and then you also support the motion with accompanying address. Sorry, a written address. You also accompany. You understand? You accompany the motion with a written address. So there are three things here: motion for bail supported by an affidavit and accompanied with a written address. So a written address is also necessary. A written address is a document filed alongside, that provides legal arguments and legal reasons why the court should grant you bail. Understand? So in your written address, for instance, you are arguing based on law that the court has power to grant you bail. Understand? And then it is proper in law for the court to grant you bail. You will now be citing cases in your written. You give the court legal authorities. For instance, in this case, the defendant was sick and the court granted him bail. Understand? In this case, so what you do, your affidavit, you state the fact as it is. Then your written address, arguments on points of law. You understand? The court is empowered to grant me bail. Is in line with my right to personal liberty. You state it there. See the case of so and so where the person was sick. That's what you do in your written address. So now, if one of the instances where the court will grant bail for capital offenses is on the grounds of e-health or the grounds of sickness. You understand? So the applicant files a motion or someone supported by an affidavit and written address. Now the affidavit must show three things. In your affidavit, you must show three things in your affidavit. That means you must state at least three things. Very, very important. Even if you're going to miss everything, don't miss these three things. One, that the sickness may affect other inmates. You understand? So the sickness is of a nature. The sickness is of a nature that can affect other inmates. You understand? That is one thing you're going to state, that the sickness is of a nature that is going to affect other inmates. And then secondly, that you have a medical report. You have a medical report to show. So the medical report is more like an evidence. You understand? It's more like an evidence that there's a medical report in proof. There's a medical report in proof of everything you're saying in relation to your health. You understand? And then that medical report, you attach it. All those. For instance, now when police officers are saying, "Oh, this is evidence against this person," we found this against this person. We find out evidence. Oftentimes, those things are called exhibits. You understand? So you attach them to your affidavit. When we say attach, you have to make reference to them, and then refer to them as maybe exhibit 1, exhibit 2, depending on how many evidence you have. You understand? So in this case now, when you tell the court that there's a medical report to that effect, that you're very sick, you have so sickness, you will make reference to that medical report and then tag it as maybe exhibit A or exhibit B, or either exhibit 1 or exhibit 2. When we see the draft of affidavit, you will see how we made reference to the exhibit. And then the last thing you state in your affidavit is that there are no sufficient medical facilities to take care of your illness. You understand? So this is one of the things you state in your affidavit. The last one, that there is no available facilities. You understand? Well, probably the prison or detention center your head. Maybe they have medical doctors there, but they don't have enough equipment to take good care of you. Maybe you require urgent heart surgery and they can't do that. They have to fly you to the UK. So you state it in your affidavit. So another exceptional circumstance where a person charged with a capital offense will be granted bail is where there is substantial delay of investigation, prosecution, or trial exceeding 1 year. So when a person has been tried beyond 1 year, someone has been tried from January, February, March, April, and then it's beyond 1 year. In such an instance, the person should be entitled to bail. Understand? The person should be entitled to bail. At least he should go and see his family that's tried. Understand? Then any other circumstances which the court considers to be an exceptional circumstance, the court can grant bail as well for a capital offense. And then another gradation or another grade of offense is felony. Capital offense, felony, misdemeanor. Understand? So another grade of offenses are felonies. By now we should know what are felonies. Understand? Offenses punishable, I think, with 3 years or more upon conviction. So now, can bail be granted for felonies? When a person commits a felony, can bail be granted? The law is generally yes. You understand? The court can generally grant bail to a defendant charged with a felony. You understand? The court can grant bail to a defendant charged with a felony unless the court is of the opinion that the person, if he's released, he may commit another offense. You understand? Or unless the court is of the opinion that the applicant, that is the defendant, if he release, if he's released, he might attempt to evade trial. Maybe on the next of trial now, we won't see him again. He'll run away, or he may intimidate witnesses if he's released. Maybe he's a bad boy, he's a cultist. He will now start going to warn his witnesses, that kind of thing. Or he may conceal or destroy evidence. Maybe there's an evidence in his house or somewhere he's hiding, an investigation is on, why try, all this kind of stuff. The court might say, fine, because we believe if we release you now, you might go to destroy some evidence or conceal some evidence. We're not going to grant you bail. And then it is also possible that the defendant may interfere with proper investigation of the offense. You understand? Maybe in the course of trial, police officers are still trying to investigate to see if they can come up with more probable and palpable evidence. You understand? So if he's going to interfere with the investigation, or maybe he's going to jeopardize the criminal justice and bail system, you understand, with his actions, whatever. So in that case, the court is not going to grant him bail. And then for other offenses like misdemeanor and the simple offenses, you understand. Example of misdemeanors are like I think fighting in public. Example of simple offenses are like traffic offenses. When the traffic is red and the traffic light is red and you're moving, that's what they call simple offense. You understand? Whereas misdemeanors are a little bit higher than simple offenses. So in any of these types of offense, the court, yes, can grant you bail unless there are also justifiable circumstances why they should not grant you bail. You understand? So what are the factors that the court will consider before they grant a person bail? There are certain factors the court will look at before they grant you bail. Remember from the beginning, we noted that bail is discretionary. When something is discretionary, it simply means that it is within the choice. You understand? It is within the volition of the person or the authority having the power to do so. Whether he chooses to do so or not, it is within his volition. It is within his will. You understand? He can decide to or not. He's not bound by any rule. So when a person wants to exercise his discretion or choice, there are certain factors he will usually consider. You understand? There are certain factors he will usually consider. So in the case of bail, the court will usually look at the nature of the offense and the severity of the punishment prescribed. Understand? So the court usually look at the nature of the offense and the severity of the punishment prescribed before the court can grant bail. Maybe the person committed the offense of rape. The nature of the offense is weighty. Maybe the person went to rape a minor, defilement, violation. The court might be incensed or disgruntled and will not want to grant bail. Maybe he might repeat such a hideous act. You understand? And then the court will also look at the character and quality of evidence against the accused. Imagine if, for instance, police are prosecuting someone for housebreaking and they are not even showing any reasonable evidence at all. They're not bringing any valuable evidence, you understand? So the character and quality of evidence they are tendering against the person is of no weight. If the person applies for bail, why won't the court? The court is just granting bail, you understand? But where the evidence are so clear that he committed the offense, the court can also consider that and refuse to grant the person bail. And then the possibility of the accused interfering with further investigation or prosecution of the case if granted bail, and then the prevalence of the offense. So the court might look at how prevalent the offense is when the offense is rampant. One issue about prevalence of offense as a factor is that when an offense is rampant and then somebody commits that offense and is in court, oftentimes the court will want to use that person, as a mark of deterrence so that others can use that person to learn. Understand? So people can see how punishment may be meted out on that person so that others can be deterred from doing that. So when an offense is prevalent, it's rampant. You understand? So the court can say, why should we release this person when we are looking for people like this? The offense is everywhere. We need to curtail it. You get? And then we also look at the safety of the defendant as well. If the court believes it is safe for the defendant to remain in custody, maybe he committed an offense and then the family and the relative of the victim have sworn to kill him, or maybe there are reasonable belief that he will be killed if he's brought out. The court can just keep him there. And then the possibility of him committing similar offenses, the criminal record of the defendant, the court will usually check, is he a first-time offender? Courts are usually lenient when it comes to first-time offenders, but when a person is a second-time or a third-time offender, the court might just consider you a habitual lawbreaker, and then they will not want to grant you bail. And then whether the defendant is going to be available or he's going to jump bail, the court will also consider, for grant this guy bail now, he might run away. He won't want to stand trial. And then the e-health, you understand? If the suspect is sick, we actually looked at that earlier. And then they need to balance the interest of the defendant against that of the larger society. It is possible that the defendant is a nuisance. You understand? He's a gangster, causing nuisance, causing problem, causing unrest, causing restiveness, whatever, insecurity in the society. So maybe, yes, he has a right to bail. It's his right to personal liberty. But if we release him, we're endangering the larger society. The court can look at that and refuse to grant him bail. And then it's relevant to know that bail must not be refused as a form of punishment. You understand? There are several factors that the court has to consider. The court must not, in its consideration, and be like, we're not granting you this bail, so we'll punish you. You understand? Maybe the person has not been of good conduct, or maybe the court does not just like the defendant, so they want to punish you, that kind of stuff. The court has a sundry of factors. Punishment is not one. Understand? Punishment is not one. And then I will look at courts or look at jurisdiction that use summons in applying for bail pending trial. I told you that some jurisdictions, they will use summons, some will use motion. They all mean the same thing. It's just a variation, and this variation applies only for bail. You understand? It applies only for bail. So, for instance, ACJ Lagos High Court South, the Federal High Court and the NIC uses summons. You understand? Uses summons. Why ACJ Kano and the High Court of the FCT Abuja uses motion on notice. So now, when a person is being tried at the magistrate court, what is the procedure for bail? We have seen that the procedure for bail. We have seen the procedure for bail in the High Court. So now, when a person is being tried at the magistrate court, what is the procedure for bail? Now, in practice, they say bail is made orally after the defendant takes his plea, unless the magistrate prescribes otherwise. So the implication is that in magistrate courts, you can apply for bail orally. You understand? It must not be in writing. In superior courts, we say you must put it in writing, that kind of stuff. So in magistrate, you can go orally and apply for bail. It will still be valid. And then another thing we have to look out for is the fact that it is possible that a person may apply for bail at the magistrate court. You understand? Maybe the magistrate court has jurisdiction over a matter, and then a criminal matter is being tried in the magistrate court, and the person has applied for bail at the magistrate court, and then the magistrate refused. You understand? It's possible, and then the magistrate refused to grant the person the bail. So in that case, now, what is the person supposed to do? What the person is supposed to do is to apply for bail at the High Court. You understand? What the person is supposed to do is to apply for bail at the High Court. And then if, for instance, it is a High Court in the South, what he's going to apply, he's going to apply for bail by way of a summons for bail supported by an affidavit and a written address. And then now in his affidavit, he must have to attach two things. In his affidavit, he must have to attach two things. You understand? So he must attach a certified true copy of the charge sheet. A certified true copy of the charge sheet that was used in the magistrate court, and a certified true copy of the ruling of the magistrate court refusing bail. You understand? So it's going to be attached as an exhibit. Exhibit 1, exhibit 2. You understand? So that is so this is a procedure by way of summons for bail supported by an affidavit and a written address. In his affidavit, he must have to attach the certified true copy of the charge sheet that was used in the magistrate court, and certified true copy of the ruling of the magistrate refusing the bail. When we get to the samples, you also see how it is drafted. You understand? You also see how it is drafted. And then where there are several defendants, the procedure is the same, but just that one motion or one summons, depending on the jurisdiction, may be used. But the affidavit must be separate. Affidavit must be separate because affidavit has to do with facts. Affidavit has to do with facts. It has to do with facts. because the reason this person is seeking for bail might be different from the reason the other person is seeking for bail. You get. So one written address may also be used where the argument, that is the legal argument, is consistent between the two or three defendants. But if the legal arguments are different, like for instance, the reason this person is applying for bail is different from the reason, like legal arguments in support are different. This person is relying on the case of this, while this person is relying on the principle in that, and they're applying for bail jointly. In that case, it should be proper to use two different written address. And then where bail is refused at the High Court. Now, if bail is refused at the High Court, what the applicant is to do is to appeal. You understand? You will have to appeal to the Court of Appeal. I think those days in Lagos campus, there was this argument whether it is to apply to the Court of Appeal or it is to appeal to the Court of Appeal. You understand? But then I think according to Leonard Ugu Esquire, he said it cannot be an application. If the magistrate refuses, if you are going to the High Court, it is a mere application. But now, if the High Court refuses, you are no longer making an application to the Court of Appeal. You will appeal their decision. You understand? And then Leonard Ugu said it cannot be an application. You can't be applying to the Court of Appeal because in whatever you apply, in whatever you are filing at the Court of Appeal for the purpose of that bail, you must put a notice of appeal. You understand? A notice of appeal is that originating process that commences an appeal. Like, it's the document you file in order to commence an appeal. They call it notice of appeal. So he said that if the High Court refuses bail and then you now want to apply to the Court of Appeal, because you must attach your notice of appeal, you understand, it is no longer an application. It has become an appeal. You understand? So you are appealing against the decision of the High Court. Unlike from magistrate to High Court, where you just apply when the magistrate refuses. In this case, if the High Court refuses, you are appealing that decision, and then at the same time asking them to grant you the bail. You understand? And then it's still in the Court of Appeal. Court of Appeal have their own procedure, but it's not that different. In the Court of Appeal, you go by way of notice of motion. Understand? You apply by way of notice of motion for bail. Notice of motion or notice is the same thing. It's just nomenclature. You understand? It's by way of notice of motion for bail, supported by an affidavit and written address. And then the affidavit in this case now, since you are appealing the decision from the High Court to the Court of Appeal, the affidavit is going to have attached as exhibits certified true copy of the ruling of the High Court refusing the bail, certified true copy of the judgment of the High Court in that particular case, certified true copy of the charge sheet, certified true copy of the application made to the High Court, and certified true copy of the notice of appeal which you filed, which you filed for the purpose of appealing the decision. So now, what are the conditions or what are the terms for bail? The conditions or the terms for bail, they're not conjunctive. You can just do one. If you do one, you're okay. You understand? If you do one, you're okay. There are conditions or terms that a person must fulfill before he will be granted bail. The conditions are different from the factors. You understand? Factors are what the court looks, what the court considers. You understand? But the conditions are mandatory. Is more like an obligation on you who is seeking bail. You understand? If you need bail, you must do this thing. It's compulsory. You have to do it. So an applicant for bail, that is a defendant standing trial, must have to either provide a surety. We all know what's a surety. Someone that is guaranteeing, that this person is of good conduct. I believe he will come back to stand trial whenever he's needed. If he refuses to do so, or hold me liable, something like that. Is surety. Or he can execute a bond. He can, the person applying for bail can execute a bond. Execution of a bond is money. You understand? A money that is tied to an account that is kept separate. You get? And then is subject to forfeiture. And then he can also enter self-recognizance based on integrity, not popularity. Self-recognizance is you entering to say, I'll be of good conduct. Something like that in writing. I'll be of good conduct if I'm granted bail, blah, 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 that kind of stuff. And then if he doesn't execute a bond, he can, in the alternative, deposit money in lieu of bond. You understand? He can just deposit money rather than executing a bond, but in effect, they mean the same thing. So these are the conditions or terms for bail. Understand? So any person that wants to stand as a surety, if such a person that is standing as a surety for an applicant for bail, Must be a person of good character, someone that is accepted by the courts, someone of reasonable means of income, someone of known address. You know, Oftentimes, when the court want to grant you bail, you don't just bring anybody. It's not like the court want to grant you bail and then you bring your mother and your father as sureties. It doesn't happen like that. Oftentimes, they need people who have a higher standard in the society, not necessarily based on wealth, but based on good character. You understand? Wole Soyinka he's not a billionaire, but he can stand as a shorty for you for bail. You understand? Because he's a person of he's a person acceptable to the court. You understand? But a lawyer should never stand as a shorty. You understand? A lawyer should never stand as a shorty. Is not encouraged. It's a misconduct for a lawyer to stand as a shorty. And then the practice of senior civil servants standing as shorties has also been criticized. You understand? So the practice whereby senior civil servants will always come to stand as shorties for people has also been criticized by the court in the director of security services against Nasuki. And then now we might ask, can a woman stand as a shorty for bail? This question is never necessary. Why should we be asking if a woman can stand a shorty for bail when a woman is a human being like every other person? You understand? So a woman can stand as a shorty for bail, provided she's a person acceptable to the courts. She's of a good character. She has a reasonable means of income. You understand? And she has a known address. Then why shouldn't she stand as a shorty for bail? Denying her that right is like discriminating against her on the basis of her gender, which runs contrary to Section 42, Constitution of the Federal Republic of Nigeria. And even if the woman is pregnant, even if the woman is in PUDA, whatever, she can stand as a shorty for a defendant who is applying for bail. And then there's people we call bond persons. Now there are people who have taken it as a business. Their business is to stand as shorty for people. We call them bond persons. There are, I don't know, maybe there are organizations or companies that is just their work. They just come stand as shorties for people, or where it requires the execution of bond, they will pay the money, and then the person will get his bail. So bond persons is, just like, for instance, we have money lenders. Ordinarily you go to bank and get money, or you go to a federal mortgage bank and get loan, or any institution that gives loan. You understand? But now we have money lenders, and they are registered. They even have an act, Money Lenders Act, Money Lenders Law, and all that. So we also have bonds person. Their work is just so person wants to apply for bail, no shorty. They will go standard shorty. If they have to execute a bond, they will help you execute a bond and pay the money, and then you get your bail. So that is their job. There are people like that. So if a person is acting as a bonds person, such a person must be a person of unquestionable character. He must be a person of good character. And then if it is an organization like a company acting as providing bond services, such a company must also be composed of persons of unquestionable character. And then the chief judge actually appoints bond persons, and then if a person is practicing as a bond person when he has not been registered, he commits an offense, punishable with a fine of 500,000 imprisonment for 1 year. And then where, for instance, bond persons has acted as a shorty for you, or have helped you to execute a bond in whatever sum, and then you are trying to run as a defendant, trying to flee, trying to escape, after you have been granted bail, the bond person has a right to arrest you, and then within 12 hours hand you over to the police. And then we might ask ourselves, is there any instances whereby a person who is granted bail may have that bail revoked? Now, the revocation of bail simply means the nullification, the cancellation of bail. If a person is granted bail, such a bail can be cancelled. It depends on the circumstances. So we see the instances when bail granted a person may be revoked. So where, for instance, a defendant who was granted bail jumps bail and refuses to appear in court or at the police station on an adjourned date without good cause. Someone was granted bail and then the court is to sit next month and he refuses to appear, the court can revoke his bail. Where a defendant was granted bail by a magistrate court, and then later on he is now indicted by a law officer for an offense not bailable by a magistrate, the bail is revoked. So where, for instance, a defendant committed an offense within the jurisdiction of the magistrate court, such as fighting in public, AFRI, and then while the magistrate court granted him bail, he then went on to commit a capital offense, and then police officers arrested him. That is bail for AFRI or whatever. It's automatically revoked. You understand? He cannot say I'm on bail. You can't arrest me. I was granted bail for like 4 or 5 months. I was granted bail. You understand? So he's going to be arrested on the basis of the new offense, because the magistrate does not even have the power ordinarily to grant him bail in the case of capital offense. And then for instance, where the court granted a defendant bail pending trial, and then judgment has been delivered, and the person is probably convicted. Whatever bail that was granted to him is automatically revoked. I told you that a person has a right to personal liberty, and even if he's tried, for instance, he's been charged for the offense of stealing. Even if he's charged for the offense of stealing, it doesn't mean you should be keeping him at the prison, because cases are long. I join today, tomorrow I join. The person can just apply for bail, let him go on with his life while they conclude the matter. Yes, so immediately the matter is concluded and he's found guilty and convicted, his bail is revoked. You understand? His bail is revoked. And then if the shorty dies, the person who stood as a shorty for him dies, or the person who stood as a shorty for him becomes bankrupt. You understand? In that case, his bail is revoked, or the person who stood as a shorty for him applies to be discharged from his responsibilities. So I no longer want to stand as a shorty for so person. Cancel my name. In that case, his bail is revoked. And then where, for instance, upon arraignment, in the case of police bail, you understand? We talked about police bail some time ago. Now, when police officers arrest the person, you understand? When police officers arrest the person, and then maybe they're investigating, within that period of time, say 24 hours or 48 hours, you understand? Or, police officers can grant the person bail, and then while they continue with their investigation, and decide if they want to maybe take him to court or whatever. So immediately the person is taken to court, that bail granted by the police, that administrative bail granted by the police is automatically revoked. And then if the person needs another bail, he has to apply to the courts that is trying him presently. And then when bail terms are also breached, now a person may be granted bail and then certain terms might be imposed on him. The court can revoke the bail if he breaches those terms. For instance, I think when they granted Nnamdi Kanu bail long time ago, one of the terms they give him is that he should not be in a gathering more than 5 persons or so. Some of the terms they gave him were stringent. You understand? So and then he violated most of those terms, like indiscriminately. He broke them with reckless abandon, and then so that is more like an example of when your bail can be revoked, when the terms upon which the bail was granted is breached. And then where, for instance, a shorty failed to produce a defendant, I told you something about shorties. You understand? I told you something about shorties. One major factor about being a shorty is that you usually make some avowments, like I know this person is of good conduct. If you grant him bail, whenever he's needed in court again, he's going to appear. The court is sitting next month. I will make sure he comes next month. Understand? And then if he fumbles, like if, for instance, he escapes or whatever, he will hold me liable. Yes, so a shorty is more like a guarantor. He's more like trying to guarantee the liability of another person. You understand? So, what is the consequences if, for instance, a shorty failed to produce a defendant does not he does not come to court in the next adjourned date? For instance, he doesn't come to court in the next adjourned date, and then the court is asking, where is the shorty who stood as a shorty for this defendant that escaped? The shorty should provide him, because that is part of his guarantee. He should provide the defendant. So what's the consequences if the shorty cannot, like, he doesn't know the whereabouts of the defendant? Now, the shorty cannot be tried in court. Such is unknown. You cannot try a shorty for failing to bring a defendant to court. Such a procedure is unknown to law. You cannot try him. He will only have to forfeit the bond given. So if the shorty probably executed a bond in the sum of maybe 50 million or so, the court will require him to forfeit that bond. He will have to forfeit that bond. He will have to forfeit that bond. He won't get back the money again. You understand? He won't get back the money again. And then if he refuses to forfeit the bond, then if he refuses to forfeit the bond, then he may now be imprisoned. You understand? He may now be imprisoned. If he refuses to forfeit the bond, he may now be imprisoned. See, Dume against FRN. And then now you might ask yourself, is a suspect in custody entitled to his own medical practitioner? You know, is a suspect in custody? You know, we are talking about suspects when, for instance, they're applying for bail. One of the reasons they usually give is that the medical facilities in the detention center is not competent enough to cater for them. You understand? So while in custody, can the suspect say, "Okay, get my doctor, let him be treating me here"? No, such a suspect ordinarily is not entitled to his own medical practice medical practitioner of choice, unless in the case of special circumstances. For instance, the prison center or the detention center can say, "Okay, bring that your medical doctor from Germany, from UK that you said is very competent. Bring him in." You understand? And so he's going to treat here in detention. And then we look at the power of magistrate to release detainees on bail. The chief magistrate or any other designated magistrate carry out what we call monthly inspections of police station and detention centers. He has the power to do so. You understand? So he can inspect records of arrest, and then he can grant bail to persons within his jurisdiction. You understand? Within his jurisdiction, he can grant bail to persons within his jurisdiction, except those in prison to which bail was refused. And then high court judges inspect detention centers of federal government agencies. Now, the essence of this is that, imagine if magistrate is going about, although these things I believe exist mostly in paper, the magistrate don't, I believe they rarely do this, because if they do this, there are a lot of people who are in police station, who are in police station and other places who ordinarily ought to be granted bail. Some DPO can be, they can be stubborn. You say they won't grant the person bail, let them see what will happen, that kind of thing. Or they will say he's a hardened cultist, blah, 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 that kind of stuff. So the chief magistrate or any magistrate designated by the chief magistrate, can go to police stations, from one police station to another to check, and to see whether there are some persons that ought to be granted bail. And then if the magistrate... Then the magistrate, in the course of cross-checking those police station and detention centers, can ask for, some document like arrest record. Let me see record of arrest you did for this month, or let me see record of arrest you did in the past 7 months. Let me know if there's anybody that is unduly held here. You understand? So the officers will have to cooperate with the magistrate. If they deny the magistrate such records and documents, is a misconduct punishable under the police regulations. And then chief judges have the power to release detainees. You understand? They can release detainees awaiting trial, although such release is not a discharge or an acquittal. You understand? So if a person is awaiting trial, maybe he's awaiting trial for like 1 year or 2 years, chief judge can just say, "Okay, just let me grant you just go." You understand? It's more like a bail. You understand? It's more like a bail. So, okay, just go. Let me just release you for the meantime, pending your trial. Whenever your trial comes up, then you can start coming to court. You understand? It's not a discharge. It's not an acquittal. The person is not innocent. You understand? But it's just for the purpose of ensuring his personal liberty. His right to personal liberty. But the chief judge authority, this authority by the chief judge applies only to pre-conviction detainees. In other words, it is only detainees that has not yet been convicted. People are waiting trial 1 year, 2 years, 3 years. Chief judge can say, "Yeah, go, pending your trial." You understand? So he cannot exercise his power in respect of a person that has already been convicted. You understand? If a person has been convicted, you cannot release him. You understand? He can only be released by virtue of what we call prerogative of mercy, which can be granted only by the president or the governor, as the case may be. But then the chief judge can release people who have been held longer than the maximum sentence for their offense. You understand? So if a person has been held longer than the maximum sentence. Maybe the maximum sentence prescribed 10 years and the person has been held in detention for like 15, 17 years. The chief judge can release the person. And then there's something called remand order proceedings. There's something called remand order proceedings. We talked about it before some time ago. That is one of the instances where the magistrate court can grant bail for capital offenses. For capital offenses. So now we want to look at what is remand order proceedings. Now, before we look at remand order proceedings, I would like us to know there's something called holding charge. Now, a remand order did not come to be on its own. You understand? There was an anomaly, there was an irregularity, there was something negative that was occurring that remand order proceedings came to cure. You understand? There was something that was occurring that remand order proceedings came to cure. Now there's something called holding charge. Now holding charge was prevalent before remand orders was then brought to cure the mischief perpetrated by police officers in the course of their holding charge. So in that holding charge now, by virtue of a holding charge, see what police officers do. Maybe police officers arrested a person for an alleged offense, and then they are investigating the person. You have to bring the person. You have to bring the person to court within 2 months if the person is not entitled to bail, or in any other instance within 3 months. You can't hold a person in perpetuity at a police station. You understand? So what police officers will do most time, in order not to breach the person's right to personal liberty. You understand? So once they hold you, they will then take you to court. They will take you to the magistrate court. They will file a baseless charge. The charge is baseless. You understand? They will just file a baseless charge. They don't have any valid evidence against you yet for that allegation, but they will just file a baseless charge, a charge that is worthless. That might not even relate to the offense they are investigating you for. And the magistrate will not even hear the charge. You understand? He will not even take the charge. You understand? The magistrate will not even take the charge, but they will just file the charge and then bring you to court. They will just file the charge and then bring you to court. They will just file the charge and then bring you to court that day. They will file the charge and then bring you to court. You understand? And the purpose of this is just so that let it not be like they have not brought you to court within a reasonable time. You understand? And then when they do that again, they will take you back to police station. You get? So at the end of the whole day, you see that it's more like they are holding you in perpetuity. They will detain you. Sometimes they will detain somebody for 6 months, 7 months, 5 months, 4 months. Why? All in the name of investigation. They are investigating. They will say there's a holding charge against him. They are investigating if you really committed an offense. So imagine when you're investigating if someone is really committed, like you're looking for evidence. Imagine when police officers are looking for credible evidence against you. Are they not supposed to let you go while they look for the evidence? But they will hold you in their detention facility. Why they will not be looking for their evidence. Then when they see that, they want to breach your right to personal liberty, they will take you to magistrate court and do what they call holding charge, whatever. They will just file a baseless charge before the magistrate court. You will not even take your plea. The charge will not be read to you because ordinarily that charge is worthless. You understand? And then they will put you back at the detention center and continue the investigation. So that is what they call holding charge. It's unconstitutional, it's illegal, it's in violation of a person's right to personal liberty and their freedom of movement. You understand? So remand order proceedings came to cure the defect of this holding charge. Remand order proceedings came to cure the defect of this holding charge. So a remand order proceeding is more like a refined constitutional holding charge. But in the case of remand order, the court can grant you bail. In the case of remand order, the court can even discharge you. You understand? So in the case of this remand order, they say it's a procedure where on the basis of probable cause. You understand? So there must be probable cause in a remand order. Police officers won't just hold you. In the case of remand order, they must establish to the court that there's a probable cause. You understand? That the defendant has committed an offense. And then the defendant is usually detained for a limited time pending investigation. You understand? So in the case of remand order, there's a probable cause that the person has committed an offense, and then the person is now detained for a limited amount of time, allowing police officers to get necessary investigation. And then in the course of that investigation, the person might be granted bail. You understand? In the course of the investigation as well, if the court is of the view that there's no, these police officers are just wasting, they are just wasting time. Like they're just wasting the time of this young man, the defendant. The court can grant the court can discharge the defendant. You understand? So that's the major difference between remand order and holding charge. Unlike a holding charge, where it is within the arbitrary discretion of police officers to do as they want, holding a person almost in perpetuity against his fundamental rights. You understand? So remand orders must be in writing and cannot be made orally. And the court has heard in the case of Lifadejo against Johnson that remand proceedings and orders are constitutional. They are valid. You understand? So if you want to apply for a remand order, if the police officers want to apply for a remand order, it is usually by way of ex parte motion supported by an affidavit and written address. And then in Lagos, you use Form K. While in Abuja, you use Form 6. Now, when you see all these, in the course of your work, when you see Form 5, Form this, Form that, it's just a document. Like, if you're like when you were applying for JAMB, there's a form you feed now. You printed JAMB form. You understand? So, like for instance, in your corporate law, although we'll get to corporate very soon. In your corporate law, you'll be seeing Form 1, Form 2, Form 3, Form CAC, this, Form CAC. Those things are just filling the gap. The normal form, where you fill in the gap, your name, this, you understand? So they also use it in remand orders. So the factors the court considers while granting an order of remand include one major factor is considered by the court, that is whether or not probable cause is established. You understand? So where a probable cause is shown, there are probable cause or valid reason, justifiable grounds to believe that there's need to hold this guy for some time. You understand? Either because it is really true that he committed the offense, and this investigation that police officers were doing will yield some positive results, or there are grounds to believe that if you release him, he might commit the same or similar offense. So probable cause must be established. Probable cause must be established. So you see that in remand orders, the court is more involved. You understand? The court is involved, and it's more like it's made with the consent of the court, unlike a holding charge where police officers on their own. Holding charge is not constitutional, it's not valid. There is no law providing for holding charge. It was police officers that was just doing that one on their own. You understand? They will hold a person for a long time, and then when they see they want to breach, they will bring you to a magistrate court, file nonsense charge. They won't even read the charge to you, and then they will take you back to detention and continue their investigation. But now you notice that in remand order, it's more like you are seeking the consent of the court. The court is more involved in remand orders. It's not within the whims and caprices of the police officers to do anyhow they want. So if you want to carry out a remand order against, if police officers, for instance, want to carry out remand proceedings against a person, that is to hold him for a limited amount of time pending investigation, they must have to establish probable cause. There must be probable cause why the person should be held for that limited amount of time. You understand? And then what is the lifespan of a remand order? Like I told you, one of the distinction between remand order and holding charge is a holding charge is fixed almost in perpetuity. Somebody can be held in detention, police facility for like 2 months, 3 months, 5 months, 6 months, 7 months, even getting to 1 year. Police officers will say they are still doing an investigation. You understand? But remand order is not like that. Remand order has limits. You understand? Remand order has limits. And then they say the lifespan of a remand order will depend on the jurisdiction. Under the ACJA, they say it is 14 days in the first instance, and then it is renewable for another 14 days upon good cause shown. So the person may be held in custody for 14 days, and then after the 14 days, if there is still no valid evidence, it can be renewed again for another 14 days for the person to remain in detention. If good cause is shown, if police officers show good reason why they should keep the person again in detention, the court will allow them keep the person in detention again for another 14 days. You understand? And then under ACJ Lagos, it is 30 days. It is 30 days in the first instance, and then renewable for another 1 month upon good cause shown. While in ACJ Kano, it is 21 days in the first instance, and then renewable for another 14 days upon good cause shown. And then after the second renewal, if the suspect remains in custody after the second renewal, the second 14 days or the second number of days in other jurisdiction has expired, and the person is still in custody, police officers, have not still released him. Now, the magistrate will issue a hearing notice to the IGP, to the Commissioner for Police, to the Attorney General, requiring them to justify the continued detention and requiring them to justify the continued detention of the defendant, and then we then adjourn for another 14 days. So you see that in this case, the court is more involved. The court is like, this is the expiration of the second renewal. So why is this guy still in detention? Have you people not still concluded your investigation? You get. So the court will even have to invite the IGP, Commissioner for Police, Attorney General. This goes to show that the court is cautious about the person's fundamental rights. You get. And then under the ACJA, the court may grant the suspect bail upon application if he remains in custody after the second renewal. So after the second renewal, under the ACJA, the court can just grant him bail. Say, okay, oh yeah, just go on bail first. Why these people continue their investigation? And then the detention of the suspect may be extended for a final 14 days if good cause is shown. You understand? So after that second renewal, they have called the IGP, Commissioner for Police, Attorney General. Now, if good cause is shown, the court can say, okay, this is final. Hold him for another 14 days. This is final. You understand? I'm allowing you this now because you have shown good cause. You have promised me, okay, within this week you get evidence, everything is in place, blah, 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 Final 14 days. After this final 14 days, the defendant is going to be discharged, you understand, with or without an application. So whether or not he makes an application to be discharged, after these 14 days, if the police does not still come up with any relevant evidence, they will have to discharge the defendant. So it's relevant. So you see in this case, a remand order is procedural, you understand, and the court is more involved. It's within the power and the consent of court, whatever they're doing. Unlike holding charge, which police officers on their own innovated, you understand, holding people indiscriminately against their fundamental rights to personal liberty. So in Abuja, the lifespan for remand order is 63 days. Lagos is silent as to the lifespan. You understand? But this does not mean that in Lagos a person will be held in perpetuity. You understand? The person might still be entitled to bail and discharge at the appropriate time. And then we look at the distinction between holding charge and remand order. You understand? So in terms of legality, holding charge, like we said before, is illegal, is unconstitutional. You might see case of Shagari against COP, Onagorowa against states. And then in terms of commencement as well, how do you commence them? A remand order, in the case of a remand order, there's no initial charge. You don't file any charge, you understand? It is commenced by way of a motion ex parte. Whereas in the case of a holding charge, they will usually file one nonsense charge in court. You understand? They usually file one nonsense charge in court, and this is even when they have held the person for some time in order not to violate the person's right to personal liberty. Sorry, the person's right to be tried within a reasonable time, although he still hinges on his right to personal liberty. A person in custody must be tried. You won't just keep him in detention in perpetuity. You must have to try him. You must have to bring him to court. So they will just file a baseless charge, against the person. And in terms of time limits, holding charge has no time limit. It's at the discretion of the police officers that are doing it unconstitutionally. But remand order has time limits. And in terms of purpose and grounds, you understand, oftentimes remand orders, like we see, there's probable cause. You must have to establish probable cause to the court before the court can allow you to commence remand proceedings against a person. But in the case of holding charge, oftentimes it's at the discretion of the police. You understand? That is at the discretion of the police. And the holding charge, when they bring you to court on the basis of that baseless holding charge, the purpose is simply to avoid the effect of Section 36 of 4 and 5, which requires them to bring you to court within a reasonable time. And then in terms of discharge and bail, you know that in remand order proceedings, a person can be entitled to bail and to be discharged as well. But in holding charge, nobody is granting you bail. The court is not even involved. The court is not even involved. Okay, so we are done with the theory aspect. So now we look at the draft. So now what we have here is a sample draft of an application for bail in respect of a capital offense on grounds of e-health. Now somebody is applying to the court to grant him bail due to his e-health. Yes, and the fact is sick. So now this is the first. This is the application, the basic application to be filed. So now he's in the High Court of Lagos State. So ordinarily, it should be summons for bail. And then I hope you're noticing the state of Lagos. So he's not just in charge. You understand? As long as criminal matters are concerned, for Lagos, the prosecutorial authority is the state of Lagos. So whether you're drafting your bail, whether you're drafting your charge, whether you're drafting your, whatever you're drafting at all, the state of Lagos is what they use. They don't use the state. You understand? But then in every other state, in any other state at all, Kano State, River State, Bayelsa State, what you just put there is the state. You understand? You will just use the state. So now this is summons for bail. Yeah, this is summons for bail, brought pursuant to the relevant sections, and then you command the parties to consign to you command the parties consent to appear before the High Court sitting at so time, and then you pray. You pray for the following orders. An order of this honorable court admitting the defendant applicant to bail pending trials. Oftentimes in exam, they might just ask you to draft only the application. If they ask you to draft only the application without any supporting documents, it's just this draft they're going to give. You understand? And then most times in all these drafts, they look at your prayers. You understand? Your prayers is this order, an order of this honorable court admitting the defendant applicant to bail pending trial. So you must know how to draft your prayers. Very, very important. When we get to civil litigation, you know that your prayers are very, very important. Knowing how to draft your prayers are very, very important. And then you date it, and then you sign. You sign. Is your counsel that will do this one, you sign. But in an exam scenario, you have to sign, and then for service on the relevant party, the complainant, respondent, Attorney General of Lagos State, Ministry of Justice, Lagos State. And then we go to the affidavit. And then we go to the affidavit in support of the summons for bail. You will notice that affidavit has a pattern in which it is drafted. And this pattern is very, very important. Affidavit has a pattern in which it is drafted. And this pattern is very, very important. It's very, very important to know how to draft your affidavit. It has a pattern. For instance, after the heading, the parties, the next thing you get is an affidavit in support of the summons for bail. And then you notice that you have to introduce yourself first. So whoever that is deposing to the affidavit. Now, a person to depose on affidavit might not necessarily be the defendant. You understand? It might not necessarily be the defendant. For instance, when we were learning this draft in school, I think the lecturer was like, yeah, the defendant can depose to the affidavit himself, or a medical doctor, like in the case of e-health, you understand, or a medical doctor. So the defendant himself can depose to an affidavit, or anybody, you understand, anybody who is his witness in the particular matter can also depose to an affidavit. But one major thing you need to understand is that when someone is deposing to an affidavit on behalf of a defendant, such a person must state how he got the information that he knows. Such a person must state how he got the information that he knows, you understand? Especially when the person is not a party to the case, he must state how he got the information. It's very, very important, you understand? It complies with the provisions of the Evidence Act. That is section 115 of the Evidence Act, if I'm not mistaken. Understand? So any person deposing to an affidavit must state how he derived the information he's deposing to. So the first thing you have to do, affidavit in support of the summons for bail. Introduce yourself. I, Michael Lanre, adult male Christian, 48, a doctor and a Nigerian citizen of number 348 to Zumba Badu Avenue, Lagos State, do hereby make oath and state as follows. Understand? So this particular couching now, this draft, you must know it. In exam, they might give only this thing 2 marks. Just this statement, this introductory statement, they can give it 2 marks. So you must have to know how to say it. And it's going to guide you, especially in civil litigation, because every affidavit starts with this introductory statement. And then you start by, introducing yourself. And then the second paragraph will usually state that you have the consent and authority of the defendant applicant and your employer to depose to the affidavit. Understand? So that should be the second thing that person deposing to the affidavit will say, where he's not the party to the case, like where he's not the defendant himself. And then he goes on with the fact. So if you look at this paragraph 3 now, he's stating the fact that yes, he diagnosed the defendant with acute tuberculosis, and then that the medical report is here with attached to this affidavit and marked as Exhibit A. So this is what I was telling you about. That when it has to do with e-health, that there are certain things that you must depose in your affidavit, and you must attach that medical report as an exhibit. So you see what he did there. I diagnosed him of acute tuberculosis. The medical report is here with attached to this affidavit and marked as Exhibit A. So that is how you attach it. But in real life, apart from this statement you make, you will now carry a copy of the medical reports and also put inside the document called affidavit. You will find it. You will take a copy of the medical report and put inside. Then you will now make reference to it like this in your affidavit. And then you look at the fourth paragraph. Now he wants to state the information he knows, and then he has stated that he derived the information from a legal practitioner. Then he has stated that he derived the information from a legal practitioner in the firm representing the defendant applicants. You understand? And he verily believes this statement to be true and correct. And then that the defendant applicant was arrested on allegations of this and that, and then that the applicant's health situation has seriously deteriorated, and the detention center is not sufficiently equipped to cater for him. So you see, he has fulfilled the second condition by stating yes, that the detention center does not have reasonable facilities to cater for him. And then look at the third condition. He also stated it, that the defendant is now coughing out blood, and that infecting other inmates has become manifestly inevitable. In other words, the sickness is contagious. And then you can just go on to add one or two of these. Failure to grant merely to the death of the defendant. It is in the interest of justice that this application be granted. It's also important. And then lastly, this is the last statement in your affidavit. It's as important as the first statement. I solemnly and conscientiously make this affidavit, believing same to be true and by virtue of the provisions of the Oath Act. Now, if you check some textbook, your lecturer might also state it in a very or a little bit differently. Those are just variation. But the most important thing is that you are making the affidavit solemnly. That is seriously. You understand the weight of what you are doing, and then you believe everything you say to be true by virtue of the provisions of the Oath Act. So you might see some documents, some PDFs, some textbook giving a little bit of variation, or your lecturer might say it a little bit differently. You don't need to bother, provided you get the core essence of the statements. You're correct. And then at the right hand side is where the deponent, that is the person who deposed the affidavit, you have to sign. And then affidavit is usually on oath. When they say something is on oath, it means it's sworn to. It's sworn to. So in this case now, it's sworn to at the High Court Registry, Lagos, before the Commissioner for Oath. Understand? So it was sworn to before the Commissioner for Oath. It was before the Commissioner for Oath that you stated clearly that you believe what you are saying is true. You understand? And then signature and all. So motion on notice for bail. We said is used in the High Court in Kano. Motion on notice for bail is used in the High Court in Kano. Motion on notice and summons for bail. Motion on notice for bail, summons for bail. They all mean the same thing. It's just a little bit of difference in drafting. For instance, if you looked at the summons for bail, you started with let all the parties concerned. But now, motion on notice for bail, we are saying take notice. Understand? Take notice that this court will be moved on the dash day of dash. And then you do the same thing you did. You sign. You serve the other party. So, ordinarily too, if you are asked to draft for the note, you also support your drafting with an affidavit and a written address as well. And then now, what if an application for bail was refused at the magistrate court, and then you are now applying at the High Court? Now, how do you draft it? And then how do you couch your affidavit? How do you draft it and how do you couch your affidavit? Now, one thing I want to show you that's very important in these summons for bail that is made at the High Court after refusal by the magistrate is the fact that we retained the name of the commissioner. Like we retain the parties. The parties are the same. You understand? Because an application is made at the High Court, after it has been refused by the magistrate, you won't now say state of Lagos. No, the matter was originally commenced at the magistrate court. I know at the magistrate court, the prosecutorial authority is ordinarily the commissioner for police. So even if you're bringing the application to the high court after the magistrate refused, the parties are the same. It will still be commissioner for police. It's not going to change to the state of Lagos. That's the most important thing. The body is the same, service is the same. And then now we go to the affidavit. The affidavit is very, very important. So you still see this first statement, the introductory statement, where you introduce the person deposing to the affidavit, and then you introduce the person as well. So in this case, the person deposing to the affidavit is the brother of the defendant. See, oftentimes when a person is in detention, in reality, he usually cannot depose on affidavit. When a person is in detention, most of the times, he usually cannot depose to the affidavit. So it will be appropriate to use another person, maybe a material witness or any person to whom the defendant, has informed of all the relevant facts. Understand? So, he still did the same thing here in paragraph 4, by showing how he derived his information and facts. So we want to see those, in this case, there must be two conditions that should be fulfilled. That is, you must attach the certified true copy of the charge sheet and certified true copy of the ruling. So let's see how he did it. So you see paragraph 4I and II say that the defendant applicant has been charged by a magistrate court for the said offense, and attached herewith is a certified true copy of the charge sheet used in the magistrate court marked as Exhibit A, and then that the magistrate refused to grant him bail after the application for bail was made, and also attached herewith is a certified true copy of the ruling of the magistrate refusing bail marked as Exhibit B. Now, these two things now are the most important thing in this draft. Every other thing here from paragraph 5 to paragraph 8, you can just decide to add them or not. And then the usual paragraph 9, which is compulsory, solemnly and conscientiously make this affidavit, believing it to be true by virtue of the provisions of the Oath Act. You understand? So it's still the same thing. So I want you to know that in these this affidavit, it's not wrong for the defendant himself to depose to it. You understand? It's not wrong. You can be learning in class tomorrow, and then your lecturer will use the defendant as a person who deposed the affidavit. Your lecturer can also use a medical doctor in that first one, that the person is sick. You understand? In this second one, that the magistrate refused to pay, your lecturer can also use the defendant. Your lecturer can also use another party. Even in exam, you understand? For instance, my lecturer said you can use the defendant or you can use another person. But if you are using another person, you must make sure you comply with section 115 of the Evidence Act. That person you are using must state how he derived his information. You understand? That person you are using, who is not the defendant himself, must state how he derived his information. He must state how he got his information. That is what is very, very important. If you don't state that, then that affidavit is just nonsense. It will amount to hearsay. Understand? So he must state how he derived this information.